is this Rodriguez v. Garland case out of the Fifth Circuit that everybody just needs to know about, because the Fifth Circuit essentially says that an in absentia motion to reopen, in absentia removal order needs to be reopened. That is, the individual didn't show up to their hearing. They got ordered removed because they didn't show up to their hearing. It needs to be reopened if the notice to appear doesn't have the date and location of the first hearing. And that's a huge issue, because that's a huge deal, because that's the Fifth Circuit. I mean, I'd say, I don't have any statistics, but I'd say that probably most of the in absentia removal orders occurred in the Fifth Circuit and the Ninth Circuit, but a lot in the Fifth over the last 20 years. And I bet a lot of them don't have the date and time of the hearing. They're based on deficient NTAs. And the Fifth Circuit said the courts need to grant the in absentia motion to reopen, regardless of whether or not the non-citizen can show that they didn't receive their notice of hearing. It doesn't matter. It's all about the notice to appear, because the in absentia motion to reopen statute incorporates the same statute that it was issued in the Supreme Court's Chavez decision. So it's a huge decision.
For those who aren't too familiar with federal litigation, Fifth Circuit is Texas, Louisiana, Mississippi. That's the last place I thought they would make this decision, but it's incredible what they did.
Right. And so, and I don't know enough about the judges, and quite frankly, it seems like a pure statutory issue. I don't like talking about Trump, Obama, Biden judges, but like, the Fifth did it. I'm sure that there are judges not on that panel that don't agree. Who knows if the Fifth Circuit will go en banc? But right now, that is the law in the Fifth Circuit. And immigration attorneys have written me and said that they're getting cases reopened. I mean, that's a huge thing, because if you've now got a client who's married to a U.S. citizen who can adjust, you could get a case reopened. If they entered lawfully, you could adjust. If they didn't, you could do consular processing without a removal order and get the proceedings terminated. I mean, everything becomes open. You don't have the 5-year bar to consular processing with an in absentia motion to reopen. Even if you do get the 601A, I mean, everything becomes possible. Rodriguez v. Garland, September 27th. Check it out.
Wonderful.